The webinar is being recorded. Good afternoon, and welcome to our webinar. We're pleased that you could take time out of your busy day to join us. I want to remind you that there are downloadable files located in the lower left-hand corner, including a copy of today's presentation and some additional resources. I'm Kathy Bryant. I'm the manager of TMLT's Product Development and Consulting Services. I primarily do consulting work with physicians and their practices related to Hipaa, medical privacy and security, Hipaa risk assessments, and cyber risk management. Joining me today as a co-presenter is Cassie Turner. Cassie is a senior risk management representative with TMLT's risk management department, and she also does presentations, or she also does risk assessments at TMLT. Just a brief disclaimer that neither Cassie or I are attorneys, and we'd just like to remind you that we are not providing any type of legal advice. The information presented today is to be used as a resource, and anything that you choose to add to your practice, you should consider reviewing with your personal attorney. Today, we're going to discuss January 2020 updates and the release of medical records, the release of medical records of deceased individuals, and guidelines for reporting and release of PHI to health departments. So it seems like January 2020 was, many, many months ago. And there was a very important Hipaa update in January. And we wanted to make sure that all of you were aware of this because with the pandemic and all the changes that our world has been under for the last 3 months, we wanted to make sure that it did not get missed. On many occasions in this webinar series, we've discussed the individual's right to access their medical records. In fact, that has been a right in place since 2003 when the Hipaa privacy rule went into effect. Over time, this clear right of access has been confused by federal laws and Health and Human Services, or HHS, guidance as they keep changing. In 2009, the HITECH Act created the concept of third-party directive, which allowed patients to direct a covered entity to send a copy of their protected health information contained in their EHR to a third party. In 2013, the Omnibus Rule broadened the third-party directive to allow patients to direct the covered entity to send to a third party PHI in any format, not just the PHI contained in the EHR. And just to continue to confuse everyone, in 2016, HHS published additional guidance which caused a major shift in the release of PHI. The HHS guidance actually created or stated that a covered entity who chose to charge a patient for their medical records needed to do so on a reasonable and cost-based fee. Practices could charge actual charges, they could charge average charges, or $6.50. Further, HHS stated that this applied not only to records requested by the patient for themselves, but to any third party that they designated. Ciox Health actually filed a lawsuit against HHS, in which they challenged both parts of the 2013 Omnibus Rule and the 2019 guidance that HHS had provided. What the big change was in January of 2020, the federal courts found in favor of Ciox. This has important implications for your practice, and we're going to explore those now. Before we do, I want to just make one note, though, that the federal government does have the right to appeal the ruling or to simply make additional rules that could change the information. So, as always, we encourage you to have a reliable source of information to keep you current with changes of Hipaa. The wording on this slide is actually from an update that HHS provided and is also now on their frequently asked questions page. But it is provided as a download on the important notice regarding the individual's right to access their health information. Basically, if a covered entity chooses to charge a patient for a copy of their records, it should be reasonable and cost-based. It is if the records are electronic, for instance, in an EHR, and are being provided in an electronic format, then you should charge either the actual, the average, or $6.50. So again, that's relating just to the patient. This is just a further restatement of this, that when an individual patient requests access to their records or a copy of their records for themselves, then exercising this right is undisturbed and the fees remain in effect. Further, the court limited the third-party directive to requests for a copy of electronic health records in electronic format only. So that means if you have paper records, you do not have to provide them electronically unless you choose to do that. Frequently, we get asked the question about attorneys requesting records on behalf of a patient. In fact, we received just last week a question from a practice in which an attorney was requesting records on behalf of the patient on a form that I'm sure you probably have seen as well, that states something to the effect, I will pay a fee for electronic copies of the PHI maintained electronically, provided the fee does not exceed $6.50. So the question, does Hipaa patient rate of $6.50 apply to medical records provided to law firms? And it does not. I would encourage you to perhaps send one of the downloadable files on the left to the law firm and state that your regular fees for producing medical records will apply. I'm going to turn it over to Cassie to discuss the release of medical records of deceased individuals.
Great. Thank you, Kathy, and thank you for covering that update. We are hopeful that this patient rate update and this release to third parties is helpful to you guys. So let's take a look at release of medical records of deceased individuals. In our risk management department, we get this question pretty routinely. I'm sure many of you have had it in your office as well, and you get asked for records of a deceased person, probably by multiple parties, maybe by multiple family members, perhaps by a life insurance company, perhaps by a subpoena. So let's take a look at when it is appropriate to release those medical records of a deceased individual. Privacy and confidentiality is what we're going to look at, as well as what a valid consent is, and then also the definition of a personal representative. With privacy and confidentiality, that is maintained with medical records even when a patient dies. So while other privacy may expire, the privacy of medical records does not. The only exception to that confidentiality is a billing confidentiality, which means that there could still be a submission of claims to a health insurance for the most recent illness or the final illness of the deceased patient. Outside of this, there is really no exception to confidentiality outside of a court order once a patient is deceased. So who do you release the records to, and what is a valid consent? So valid consent generally under the Medical Practice Act of Texas requires a valid consent to release the records, no matter who is asking for those. And it would require it to be written and also signed. Further, it outlines what the consent should have within it in the Texas Probate Code. So, the consent should include the information or medical records to be covered by the release, the reasons and the purpose of the release, and to whom those records are going to be released to. So when this is done, the consent must be signed, obviously, by a valid person. That person is deemed the personal representative. It can be a deceased person's spouse or any other family member or who the court deems is the personal representative of the deceased. And so let's take a look at what is a personal representative. A personal representative, as I've mentioned, is someone who is specifically named by the Texas Probate Court to have that authority on behalf of the deceased. The person named as the executor in the deceased will has the first preference if that person is actually named in the will. If for some reason that person is not named in the will, the court will go through a process and a proceeding to decide who is the most appropriate person to be the personal representative. It could be a mother, it could be a father, it could be a spouse. It just depends. It doesn't specifically say if you are the spouse, then you are automatically the personal representative. Again, the court will go through that. They will determine the process of who should be the personal representative of that deceased patient. So individuals who are generally not allowed to be a personal representative are minors, people who are deemed incompetent, convicted felons, and potentially non-residents. We include the links there at the bottom for you to take a peek at those rules if you would like to. So in order to be appointed a personal representative, a person will just go to the court and apply, and as we've mentioned, the court will go through their process and they will establish who is the personal representative and provide them with the appropriate documentation, and then that documentation can then be presented to you all in your offices to validate that the person is actually the court-appointed personal representative. So a quick question, how can family members of deceased individual obtain the deceased individual's PHI that is relevant to their own health care? Speaking of Hipaa, they gave you a caveat here. So if a person needs information pertaining to a deceased family member, the primary topic that generally comes up here is maybe a cancer, and they want to know if they're potentially at risk because of their family member, then those medical records can be released for treatment directly to the treating provider. They would not be released to the family member, but they can be released to the treating provider of the surviving family member if there is a concern for some type of risk that would be passed down from one relative to the next. And Hipaa also, as we've been talking about, makes the exception for the personal representative, and so that information can also be released to them under Hipaa without any issue. So how long does a practice have to release the medical records of a deceased individual? This, to keep in mind here, when you do release the medical records, you're going to always want to validate the identity of the person first to make sure that you do have the proper personal representative that you're releasing those records to. And it is the same as it is with any other medical record release. The rule is 15 days. Again, just making sure that you verify the identity of that person. If you're unable to identify that person within the 15-day period of time, then you will want to send them a letter as to why you're not, a written letter as to why you're not releasing the records to them during that time period. One thing I will mention finally before moving on to the next topic with the release of deceased records is that if there is a litigation, then you would follow the normal subpoena process. We would recommend that you verify the subpoena. We have seen fake subpoenas before, so just keep that in mind, that that is another way that records could be obtained by someone who's not the personal representative. Again, just making sure that you are verifying that is an actual subpoena before moving forward. So as Kathy mentioned as well, we were going to talk about responding to health departments in a pandemic and how to release medical information to those who may be requesting. The OCR has recognized that there are some HIPAA privacy issues around COVID -19, but also making that information available given the pandemic and how to go about doing that. So they have put forth a document that we reference here that outlines how you can release information about COVID in particular in this pandemic without an authorization from the patient. So when sharing protective health information, you can release information for treatment just as you would to a treating provider or within a normal circumstance of releasing medical records. You can also release to public health folks. You can make disclosures to family, friends, and others, disclosures to prevent a serious or imminent threat, disclosures to media, and keeping in mind minimum necessary, that you don't want to release anything more than is actually required to get the information to that public health department. Again, with the pandemic reporting, we've also received quite a few questions about contacts tracing. We've just put some resources here for you to look at your leisure. Participation in contact tracing currently is voluntary. It is not required. We have had questions where the health department has contacted a office, and most likely what's happening there is that they are looking to notify others who maybe have been exposed. The question has been, can the clinic respond to that health department? Again, this contact tracing is voluntary, but yes, if it is reported to the public health, the CDC, someone like that, then it is okay to release that information as far as who maybe is in your office staff-wise working, so that they can notify them that they have been exposed to the pandemic. We have also included a couple of resources on the download panel, as Kathy has mentioned, specific to contact tracing, and as well as the Texas Health Trace information. There's a PDF that outlines if you are contacted by a health tracer, how to go about that, and we've put those in that download pod for you as well. So as we end most of our talks on Hipaa and the OCR, we're just keeping in mind that there are impacts of noncompliance. While we have seen some easement from the OCR with the pandemic, we just remind you to continue to be vigilant with your Hipaa privacy security efforts to avoid some of these things, time away from your patient care, financial, reputational harm. We also know that hackers are changing their tactics to exploit during this pandemic time. So again, I know it's probably the last thing on your mind, but just remaining vigilant to keep your system secure as possible. And Kathy, I think that you had a couple of other questions to go over with us, and if anyone else has a question, we do see some in the Q&A pod. Please feel free to put your questions there, and we'll just go through them.
Is, can we release patient records received, say lab results from a provider that subsequently the patient provided the records to them? I would reference you back to the Texas Medical Board Rule, Chapter 165.
Kathy, I think
that specifically talks
that you put forth that poll question after today's webinar. I will make changes to my
from another provider, and you use them for your care or treatment, then they become part of your records. And so when you get a records request, you do need to provide those labs, those notes, whatever you have received from the other provider as part of your records. There's another question for Social Security benefits being asked for from lawyers. Do fees apply? Perhaps this person can explain a bit further what type of Social Security benefits are being requested, and we'll circle back to that.
Yeah, I'll just add, Kathy, on that for specifically for life insurance claims. I didn't mention this earlier when releasing those medical records. That does not fall into health insurance, and I know they're speaking about the fees here, but in that case, if they're looking for the records to contact the survivors for life insurance claims.
Thanks for adding that. How long do medical records need to be kept after a person dies? The requirement in Texas is the same as for any medical records. You must maintain the medical records for a minimum of 7 years from the anniversary of the date of the last treatment by the physician. If the patient was younger than 18 when last treated by the physician, the records of the patient must be maintained until the patient reaches age 21 or 7 years from the date of the last treatment. So if a physician saw a patient when they were 17, they would have to maintain those records for 7 years or till age 24, because that is longer than age 21. That again is referenced in the Texas Medical Board, Chapter 165. Cassie, here's one about a deceased individual. For a deceased individual who had a power of attorney prior to death, is the power of attorney still available to get medical records after the patient dies?
Sure. So typically, this expires with the death of the patient, and again, the personal representative would need to be appointed by the court in order to get those medical records.
Great. I think this is the same answer for the next question, which is if a person is listed on the patient's medical release form prior to their death, is it valid for release after death? And those would not be valid after death until you had proved up who the power of or the personal representative is here in the state of Texas. If you're in another state, or if the medical records involve physicians from another state, the answer may be entirely different, and we would have to make sure that you're following the rules of the state that you're practicing in. Question about will we get a copy of the slides? Yes, the slides are actually the third downloadable file in the lower left-hand corner, titled May 2020 Slides. For short-term disability paperwork and FMLA, is Texas exempt from assigned release to release any medical information? You want to answer that one, Cassie?
For short-term disability paperwork and FMLA, I do not think there's an exemption. Kathy, you can correct me if I'm wrong. And if we're talking about, we're not talking about a deceased individual at this point, most likely. So the general rules for release and authorization of information would apply to this scenario.
Okay. And I would say yes. And generally, the FMLA paperwork that I have seen contains an authorization for the person to do, for the physician office to release the medical records. If that is something that you have further questions about, you can certainly use the consulting@tmlt.org, and we will actually try to get more information on this. There's a question about what is OCR. Sorry about that. We get so concerned about or we get so familiar with acronyms, we forget that not everyone knows what they are. OCR is the Office for Civil Rights. They are part of the Federal Health and Human Services, and as I lovingly call them, they are the Hipaa police. They are charged with the responsibility of actually enforcing Hipaa. Cassie, here's one. What's the best way to verify if a subpoena is real?
Sure. This one can get a little gray, or perhaps. Typically, we recommend that the first thing would be to check the dates, to check the names. We've actually seen subpoenas that have been signed by a deceased person, meaning that the date was past their death. So there's some basic things that you can look at as far as name, date, and also working with attorneys to make sure that they are actually legitimate subpoenas. Unfortunately, these forms are easily available and readily available online often, and folks can just grab a copy. and potentially forge it. So there are a couple of different ways to go about it, but some basics to take a peek at initially.
Thanks. So there's a question, can we charge SIOCs? If SIOCs is requesting copies of records, I would say, I guess it depends on why they're requesting records from you. If it is in the pursuit, or if it's for treatment or payment or healthcare operations, typically there's no charge associated with those, but we can discuss that further. If you want to send us your contact information at consulting@tmlt.org, one of us can reach out to you individually. Will this webinar be recorded, and can I listen to it again? Yes, the webinar is being recorded, and we will be sending you an email tomorrow. Typically is when they go out, and it does have the information, a link rather, on how to listen to it. Also, all of our webinars are recorded, and they're all listed on TMLT's resource page at hub.tmlt.org. Can you briefly run through the fees for releasing a paper copy of a lengthy medical record? Cassie, do you have those numbers off the top of your head?
I do not have them off the top of my head, but we can kind of tag team it here. I mean, it will depend on if you're releasing directly to the patient or if you're releasing to someone else, and then pending if you're in the state of Texas, which I will just assume. So in the state of Texas, there are some prescribed fees that you can charge to a third party. If it's to the individual, as Kathy mentioned earlier, you will want to make sure that you either have the average cost, the actual cost, or the $6.50 if you're releasing directly to the patient.
And those fees are located in the Texas Medical Board Rule Chapter 165. If you have trouble locating those, you can either shoot an email to consulting@tmlt.org and we'll help you find those. Otherwise, you're certainly welcome to, at any time, you can call the Risk Management Department at TMLT. They answer questions every day on actually releasing medical records. We've kind of gone through how many records you have to keep, all patient records. So it's generally 7 years, or it is 7 years after a patient turns 18, if they were younger than 18, or the age of 21, whichever is older. What are the fees associated with disability requests? I believe that for Social Security disability, that unless there is a stated fee allowed, those generally are provided at no fee. Are there any updates on fees? We've been covering that. Again, typically, if it is to the patient, the update is actual charge, average charge, or $6.50. If it is to a third party, the third party charges are in Texas are reflected in the Texas Medical Board, Chapter 165. Cassie, would you please repeat your answer regarding life insurance?
Sure. So if a life insurance company contacts you asking for medical records, typically you would not provide those to the life insurance company for a claim. Your best option would be to have them contact the survivors or the personal representative to follow up and get whatever they needed. That's not something that you all are required to do in the state of Texas.
So another question about fees. We had an understanding from the Texas Medical Board that we could charge $25 for records for personal copies. We're confused by the three options you mentioned. So there is confusion. We actually last year did an entire webinar just on the fees that were allowed for individuals for the release of medical records. The Texas Medical Board rule is basically says you can charge a reasonable fee, not to exceed $25 for the first so many pages. So if you are getting requests for records from patients for their personal use, you may charge the actual fee, the actual cost to copy the records. You may charge the average cost for the records, or you may charge $6.50. And the first document that's downloadable, the individual right to access their medical records on the lower left-hand corner, that is covered extensively in that particular document. See, there's a question if retiring is the amount of time required to keep records also 7 years. The requirement is the same, whether you are retiring or continuing your practice. The records do have to be available through a custodian for a minimum of 7 years, unless you're talking about records of minors, and then that would be where it's the 18 plus the 21 years or 7 years from the last service. When our physicians are on call for hospitals and they perform a procedure, do these records belong to us as a practice or the hospital? And can we release those records once they are transferred to us? Cassie, you want to take that one?
Sure. If this procedure is for a patient of your clinic and those records are part of their medical chart, then those can be re-released as part of their medical chart. I think the hospital will probably always maintain a copy as well as you. So, but I don't think there's any issue with you re-releasing those once they're put into the patient's medical chart at your clinic.
How long do we have to keep medical records sent on a CD? If those records are being reviewed, or I'm sorry, if those records are being utilized for the treatment of the patient, whether you keep them on a CD or whether you actually import them into your electronic record, those become part of your medical record, and you have to keep them for 7 years past the last visit with the patient, or age 21 if they are a minor patient and that is shorter than 7 years. Or I'm sorry, if that's the longer, how long after you've seen the patient. So if you saw a 2-year-old and got records on a CD, 7 years is not when you could destroy the CD. You would have to keep it till the child was age 21 before you could destroy those. Some Medicare Advantage plans require 10 years? Are we required to keep those records for 10 years? Those Medicare Advantage plans are confusing, and yes, if you're participating in those, I would suggest 10 years. What is the $6.50 for medical records? Is it per page, or can we charge one fee up to $25? For an individual patient requesting copies of their own records, it doesn't matter if it's one page or 500 pages, you need to, you can charge either actual charges, average charges, or a single fee of $6.50. Do we need an authorization in writing from the patient to complete short-term disability? I think we've answered that perhaps. Or is verbal sufficient? Didn't we cover that, Cassie?
Yes, we did. And as you mentioned, typically those FMLA and short-term disability forms have a default area for an authorization of the patient. So that's, I think that and a lot of those forms are standard, at least per the state of Texas, they are. So I think you're going to capture that within the form.
There was a comment about the downloadable file says it's unsupported content. If you would just email specifically to consulting@tmlt.org which document was unsupported, we'll make sure we get that to you.
I think we had another question about retiring that was addressed, and then maintaining those records for 7 years. And another question, I want to confirm if a patient gave authorization to release his or her medical records prior to his or her death, that authorization is no longer valid. That's correct. You would want to have what the probate court has assigned as the personal representative to be able to release those medical records and have a valid consent from the personal representative that the court has appointed.
There's a question about, I'm assuming it's about charging for records released for medical record review audits. I would say check your contract. If it is a managed care contract, sometimes those require that you participate in releasing those records at no charge. But without knowing more about that, I can't really address that. Is there a downloadable for more information on release of records for COVID-19? We have done 3 webinars related to COVID-19, and one of those may have the information that you're actually looking for. The Office for Civil Rights and the Texas Department of State Health Services and Texas Medical Association all have extensive resource pages on COVID-19.
And also, if they're referring to the portion that we covered today, there is a link within the slides that will take you to a PDF that outlines the release to for treatment and public health that we discussed a little bit earlier.
The next question is just curious, is there a standard price that patients are charged when requesting medical records? More and more we have seen where patients are not being charged anything for copies of their medical records. Under Hipaa, it is a patient right. So if if there is a quote unquote standard price, it would be that, the $6.50 is probably the second most standard thing that we are seeing. SciOx is requesting records for Medicare Advantage plans for both patients who are in and out of these of network to the provider. Is it legal to release the information if I am not in the network? Um, I think we might need to have more of a conversation about that. If you're requesting this, again, if you shoot an email to consulting@tmlt.org, and we will reach back out to you as far as having a more in-depth discussion about that. If a patient asks for test results that were ordered by another doctor, can the consultant doctor release those to the patient? Again, if those records are part of your medical record, then they should be included in the medical records and released to the patient if requested. If the health department requests medical records or information of next appointments for a patient with a disease that is not required on the reporting list, do we have to send them this information or should we ask for an authorization? Cassie, thoughts on that one?
If the health department is requesting the information, then if it's in relationship to the pandemic that we've been discussing, then I believe that it would be okay to release that information directly to them. Again, keeping in mind minimally necessary. With those releases, an authorization is not typically required.
I think the website, there's a question about repeating the website again. The resource page for TMLT is hub.tmlt.org. Often I will receive a record request from an attorney stating that they're representing the patient to receive Social Security or similar, and often with a photocopy stating you won't charge any fees for this record request. Is it legit? Probably would want to take a look at that. If you would share that with us at consulting@tmlt.org, we'll be happy to either take a look at it or pass it on to someone to look at to see if it is legitimate or not. Another question, this is a good one actually. Some offices are just doing virtual visits now, so they do not have patient signed medical release forms. Is it still okay to share those patient records? My first inclination is if you are needing to share those with another provider, if it's for continued treatment, that of course is okay to do without a signed release form. You can always, if you need a signed release form for some reason, you can always either email the patient, push it out through your portal, or mail it to the patient and have them send it back to you. Fax is always still an option as well. Any other thoughts on that, Cassie?
No, I think that you answered it. I know that in establishing a patient relationship, some of that was eased, as we mentioned earlier, from the OCR's perspective and being able to establish without some of that. But if it's for treatment and you're forwarding it on to another provider, I do think that that's certainly acceptable without having an authorization form.
Are we required to keep all parts of the record shared with us by other providers, or can we thin, such as covered sheets, little information pages, etc.? Um, Typically, if you have requested medical records, you need to add to your records anything that your provider is going to find pertinent, uh, and that they will use for the treatment and care of that patient. So if there are miscellaneous pieces of paper that you don't use or do not need, I think it would be okay to remove those either before scanning them. If a patient brings a stack of paper into you, the provider can always just flag the pages they want copied, and you can give them back to the patient if they're bringing them in. What do you mean by actual and average charges? So if you are making a, if a patient requests their medical records and they want them in an electronic format, and you simply push a button or a series of buttons, it's sometimes a series, in your EHR and push those records out through the patient portal, then you would only be able to charge the time that it actually took to do that. If you were providing them in paper format, you would be able to charge the time it took the individual doing the process, plus the numbers of sheets of paper, plus whatever delivery method, for example, postage. Those would be actual charges. If you don't want to keep actual charges on every single records request, you can keep them for a period of time and do an average over time, and that becomes your average charge. So that again is covered extensively in that first document, the individual right to release their medical records. What if a patient signs a release for information to life insurance? I'm guessing that was signed in order to obtain life insurance, and that would be considered a valid medical records release, as long as you can verify that that was in fact signed by the patient. When a patient transfers to another doctor and we send the records to their new office, do we still have to keep the records for 7 years? Yes. Sorry, that's the bottom line. Where do we find Texas Medical Board Rule 165? The easiest place probably is just to Google Texas Medical Board Rule Chapter 165. If you have trouble finding it, shoot us an email at consulting@tmlt.org, and we'll be happy to cover that. We just covered the actual medical actual charges, how we calculate that. Can you verify if a signed medical records release is required from a patient to send records to another provider that the office does not have listed as a provider they see? I'm assuming that the second office is requesting them. You know, you can always err on the side of the patient by asking them, by simply calling them and saying, hey, we got a request from whatever the practice name is, and we just wanted to verify that you wanted your record sent to them. If we have electronic medical records, are we mandated to release in electronic form? Or are we allowed to release the record in paper form? So again, it depends on who's asking for the copies. If it is the patient is able to request those records in the form and format that they desire. Even if you have electronic records, the patient can request them in paper and you are required to release them. Likewise, if you have electronic records and the patient wants them electronically, then you must make the records available electronically. There is quite a discussion about that on our website, the hub.tmlt.org, the individual right to access their medical records, in a previous webinar. And if you want to continue that conversation, we'll be happy to do that a bit later on. Medical records companies working for commercial payers will request records for a time frame that is outside the current carrier's coverage. Do we need to send the medical records if the patient had another insurance carrier during part of that time frame? Thoughts on that one, Cassie?
Yeah, and correct me if I'm wrong. My understanding is that if you would adhere to the time frame of their coverage when responding back to the insurance company, and items that fell outside of their coverage would not be included.
That would be my thought as well, is that it would be similar to receiving a medical records request for all records that pertain to a certain date range, and that you would just need to make sure that you only release those records that were in that date range. If a patient refuses to pay, do we waive the cost? Well, you cannot refuse to provide medical records to a patient if they owe you money. That is one of the things that Hipaa is very specific about. The Health and Human Services have gone to great length, as you will see if you read that first document in the download files, about making sure that everyone knows that it is the patient's right to receive a copy of their records. In fact, buried deep within that document, they actually say they believe that patients should not be charged. So I would be very cautious about refusing to give patients medical records based on the fact that they simply don't want to pay you, because the patient then can turn around and file a complaint with the Office for Civil Rights, and you could find yourself under investigation for failing to provide the records. Can we email medical records to patients? So basically, you can email medical records to patients if that is the format that the patient has requested. If you do not have encrypted email, you need to explain to the patient that there is a risk of providing them that way. And if they insist on you sending the records by email, then you must do that if it is to the patient. The two examples we frequently get calls on are either a mother or a parent needing immunization records for schools, or secondly, the other one that we frequently get is a patient who forgot to get a I was seen at the doctor's office note for employers, and yes, you can send those as long as the patient understands if it's unencrypted, there is a risk. Cassie, you want to take a stab at, are we allowed to release any internal communications between physicians and staff, such as telephone encounters? And if so, is it limited to patient or facility?
Sure. As far as documentation of telephone calls, particularly if it impacts a medical decision, then certainly that would be part of the chart and could be released. I don't believe that there's any limitation to releasing it, obviously, directly to the patient or to a facility. Again, and if it's something that impacts the medical decision, you would definitely want that captured and do your telephone encounters and made available to to the patient, or particularly if there's continuity of care for another provider to have that information as well.
And in fact, that is addressed in Chapter 165 of the Texas Medical Board
Right.
rule, that it doesn't matter how the encounter, whether it's in person, telemedicine, however, it's all part of the patient record. We've always required a written medical release to keep in the patient's file. Is this the preferred method, or can the patient verbally, can the patient verbally request over the phone that records be forwarded to another provider? Um, it's always preferable to get an authorization for the release of medical records to a third party. It is not required that you get a written authorization to release them to the patient themselves. I think our last question for today is, for workman's comp patients, can we release records to the patient directly or only to workman's comp? Cassie, unless you think of something else, there is, I believe it's only directly to workman's compensation that those records are required to be released.
Yes, that's my understanding.
We've gotten a couple more pop-ups since the last one. When a parent is fighting for custody and asking for a minor medical record, do we have to let the other parent have the records? I think is the rest of that question. Generally speaking, especially during the custody battle, both parents are have the right to access the medical records. If you have specific questions and if there are specific reasons, we can certainly have those, have you talk to an attorney, because the parental rights questions get very tricky. Are we allowed to release information to an emergency contact if the contact is not listed on your Hipaa form? Um, Typically speaking, no. If it's someone that is available, or someone that the patient has wanted information provided to, the answer is no. There are a few situations that there are some exceptions. So if you have a specific circumstance that you're thinking about, you can shoot an email to consulting@tmlt.org. Just a quick reminder, The slides and reference materials are there available for download. Our next webinar next month is on June 23rd. It's on telemedicine, managing your risks, another very hot topic in regard to the pandemic. I want to thank you for joining us today, especially all those who participated in our polling question. Just roughly 39% of you said that you'll be making changes to your practice based on the information provided during the presentation. If you have